The objective of this video is to review or make suggestions on the basic um, strategies on how to answer law school exams. Law school exams would try to emulate also the format of the bar exams. These are the common exam questions for the law school and the bar exams. You have enumerations, distinctions, definitions, the rational reason behind the law, and case problems. So foremost, you have the enumeration. For example, in the question, who are citizens of the Philippines? There are many ways of approaching the question. There are many ways of answering the question. One is by answering it in a bulk paragraph without any indentation here. If you see the example, bulk paragraphs in enumerations is a no-no because in an enumeration, the checker wants to see immediately the enumerated items. In a bulk paragraph, it may be difficult to point out which are the items enumerated, especially if they are not numbered. No? This is an error. This is how not to answer an enumeration question. Aside from it being bulky, there is no indentation in the answer. Second example is the use of bullets. Yes, you may have itemized your answer, but you have used bullets. You never use bullets in an exam in the law school. There is also a lacking element here, which is the introductory statement. So what am I looking at? The instructor will say, what am I looking at? Does not have any introduction on what the enumeration is all about. Also, do not use bullets because this is not appropriate in formal writing. Remember that the law school exam is a formal writing exam. This is how you answer an enumeration question. Remind the examiner of what the question is by providing an opening statement. The following are the citizens of the Philippines. Then you make an enumeration. Appropriately indicate it with letters. I suggest letters, not the enumeration, because you already have each item in numbers generally. Use semicolon, and in the penultimate answer, include and, or in instances when it's in the alternative, you use or. Okay, so formal writing requires this as a matter of continuity. Another form of an exam is the distinctions. No, when you are made to distinguish one concept with another, what are the distinctions between the inherent state powers? Again, you could make use of numbers. It's correct here. You have used numbers. You have itemized it, but what it lacks is an opening statement. You have to remind the examiner on what the question is about. Do not use bullets, as in this item. Bullets are used. That is an informal way of writing. Aside from the use of bullets, there is still no introductory statement. Never also answer in distinctions in paragraphs if there are several distinctions. If there's only one distinction, you can answer in a paragraph. But if there are several distinctions for two or more concepts, you use never the paragraph form because it's going to be confusing for the checking. Masakit po sa mata. This is how you answer a question that requires distinctions, an opening statement, and then you itemize with the use of numbers or letters your every answer, your every distinction. Again, in the penultimate answer, there is the word and to signify that what follows is the last distinction. Definition, that's another way of asking a question in the exam. What is political law, for example? Do not give your answer directly. You have to remind again the checker what he is reading. So the correct way of doing it is repeat the word or the term. Do not identify immediately. So you have to repeat political law has been defined as, rather than that branch of public law. No, you have to identify by citing the term first before you make your definition. The reason behind the law, the rationale behind the law or a concept, no? So, example, why can the state not be sued without its consent? Again, you can answer in a bulk paragraph, but what it lacks here is Yes, an indention. You can answer in paragraph if you only have one rationale. But if you have two schools of thought, you can itemize it. But the problem is, in this itemization, there is no opening statement. So an opening statement will do. And then give your rationale. Again, you can answer in a paragraph without itemizing it. If there's only one rationale, this only applies if there are two or three schools of thought. So case problem, you're given a case, mahaba yung question. Actually, ang tanong dyan is only on, it lays down the predicate for the main question. Okay? Here, was the order correct? Actually, that's the only question. So you focus on the main question on whether the order was correct or not, and you make use of the premises coming from the narration of the facts and the law that you can deem as applicable. So you answer this way, but this is wrong. The question is, was the order correct? Some of us have the ability to answer questions in the threshold, in the borderline of a yes or a no. And that is confusing, and it's irritating to the checker because the checker wants to know immediately what your stand is. So instead of giving your justification and making the checker guess as to your true answer, you have to indicate a yes or a no or a true or a false before you give your justification. Lay down your answer before your justification. A yes or a no before the answer, or a true or a false before the answer. If you're asked, was the order or was the court correct? Okay. It's different um if the question would say, if you were the judge, what would you do? It does not require an yes or no answer. You just say, if I were the judge, then you give your answer directly. Okay. But here, it's a yes or a no question. It's the most common or true or false question that needs justification. If you just answer true or false or yes or no, it does not get any credit, by the way. So what is the examiner expecting? He is expecting the appreciation and the highlighting of the relevant facts. From the relevant facts, what is the applicable law? And what is your analysis and conclusion? You're reminded here of your college days, the formation or creation of syllogisms, the first premise, the second premise, and the conclusion. The first premise being the applicable facts or the relevant facts. Second premise is your applicable law. And then third statement is the conclusion. Given your analysis, what is your conclusion? In a bar exam or a law school exam, we try to emulate also the bar exam questions. Notice here that these questions will give you the time, how many hours are given to you. It will tell you how many questions are going to be asked in the exam. It reminds you that a mere yes or a no without any explanation will not be given any credit. That you are not supposed to identify yourself. This may be considered as marking. So you don't write your name, and you are reminded to review your answers before submitting, among others. So don't unnecessary marks in electronic exams. Unnecessary marks come in the form of irrelevant expressions, including your names that you indicate na wala namang konteksto, no? Yung name mo, talagang hindi pwede yan, no? Pero yung lalagyan mo ng AMDG, bawal po yan. Those are irrelevant marks. So just answer directly. Abbreviations, do not abbreviate terms or names unless the case abbreviates it, or you mention it the first time, then you make your abbreviations later. Don't cite a case title or GR number, especially GR numbers if you are not certain. Yes, it's impressive, but it challenges the examiner, especially if it's a case not in the assigned reading for the law school. And the GR number, it challenges the examiner or it impresses him, so he will look into it. And sometimes, most of the time, if your case title cited or the GR number is incorrect, you get no credit. Do not use all caps or bold letters. Do not underline, because that is condescending. That will tell the examiner that it's as if he's not reading and he has to lay emphasis on certain points in your answer. Do not use quotation marks or colons, because it's in the old times we consider colons as indications of deletion. But now when you put colons, it's as if you are putting something off record, no? Do not use quotation marks because when you make use of quotation marks, you are emphasizing. Do not emphasize. Assume that the writer or that the checker will read everything. And of course, no cheating. Bar exams will have serious repercussions if you cheat during the bar exam. In the law school exam, it will also have, of course, serious repercussions. So those time allocation, if you have 10 exams and you have 2 hours, 10 questions and you have 2 hours, budget it that you have the first 6 finished in the second hour and the next 4 in the second hour. So you have more time to review your answers, to go back. Baka may nakalimutan o nakaligtaan. No? Pacing is important. There are more questions that are more difficult than you focus your attention on them. Reserve time by determining what these difficult questions are. And then use full sentences and simplest sentences. Do not make use of highfalutin, high-sounding words. Observe correct grammar. And of course, as an expectation, you are supposed to study well. So, thank you very much. I hope this helps.